In order to initiate a lawsuit, such as a divorce, the first step is to file the correct forms with the court, but nothing else will happen in the case until the other person has notice of what you are doing. The court does not send anything to the other person. This is entirely your responsibility. It is also important to remember that you cannot send documents and information directly to the judge. You also do not get to talk one-on-one with the judge. The other side has the right to be at all proceedings. Anything you want the judge to see has to be filed with the clerk, and a copy must be sent to the other side. Each party is entitled to full access to the information. This promotes fairness in the courtroom. Notifying the other person of your case is very important. This process is called service. This is how they know that you are taking them to court. There are several ways to serve the other person. The most important thing to remember is that you cannot serve someone by yourself.
Who is it? I have a 4 o'clock appointment with Kristen, sometimes known as my wife.
Hi Dave, how you doing?
I'm good. How are you?
Fine. How's your day going?
So far, so good. How about yours?
Well, there's some things we need to talk about. It's hard to say this. It's important to say it though. I haven't been happy for a while. Do you want to sit or?
I guess I do.
You probably should sit down. I've decided a divorce is the only solution.
The only solution?
The only solution. It's just not working. I filed these divorce papers and I'm giving them to you. You need to.
Just like that.
File for a divorce.
You're just going to give up on it like that?
Well, I think we've been working a long time, and it's just not working out, and it's just a decision that I've come to.
Well, I mean, isn't this a decision we should both make? I don't want a divorce.
I don't think from what I understand, that's just not the rule. I want a divorce, we're going to get a divorce. So, yeah, I mean, you have the right to talk to the judge, but anyway, the papers are going to be served on you. I'm going to have to give them to the sheriff, and then the sheriff's going to...
That's nice. Well, I guess there's nothing else to talk about. You get back to work. That's all you ever do anyway.
The best way to serve someone is to call the sheriff's office in the county where the individual you are serving lives. You should have the papers prepared and the address of the individual you need to serve ready before calling the sheriff. This is something they do often, so don't be afraid to ask them for assistance. In addition, sheriffs in Montana will serve the papers on your spouse for free if you cannot pay. Go to this website for the form you need to waive the service fee. Otherwise, the sheriff will charge you a small amount. Under Montana law, you can also serve papers through the mail, but only in a certain way. The other party must be 18 or over, competent, and cannot be a business. If you choose to mail the papers, you must send 2 copies of notice and acknowledgement. The acknowledgement is what the other side sends back to you, showing that they received the papers. You must also send them a stamped envelope so that they can return the acknowledgement to you. Receiving this form back from the post office is not enough to complete the service requirement. Service is only accomplished through the mail upon receipt of the notice and acknowledgement forms. If you do not get the notice and acknowledgement back within 20 days, you must have the papers served either by a sheriff, deputy sheriff, constable, or a professional process server. You can find a process server online or in your phone book. Following the rules for serving a person in a lawsuit can become impossible when that person is nowhere to be found. Fortunately, Montana law has a different way to serve the necessary papers when the person you're looking for disappears. Montana law allows service by publication. This means that if the sheriff cannot find the person that the documents need to be given to, you can publish the information that would normally be in those papers in the newspaper. Before publishing, you have to file an affidavit, which is simply a written statement that says the person lives out of state or cannot be found. The affidavit must be filed with the clerk of court. After that, you can get permission from the court to publish the information in the newspaper. When you get permission, you can publish it 3 times, once a week for 3 weeks. Make sure you use a newspaper in the county where the courthouse is located. This publication has to say why you are taking the person to court and, when necessary, a description of the property involved in the dispute.